Gios-Samar Incorporated vs. Department of Transportation and Communications, and Civil Aviation Authority of the Philippines. GR number 217158. Promulgated on March 12, 2019. This case was decided by the Supreme Court en banc. And the decision was written by Associate Justice Francis H. Hartaleza. The 1987 Constitution and the rules of court promulgated, pursuant to its provisions, granted us original jurisdiction over certain cases. In some instances, this jurisdiction is shared with regional trial courts or RTCs, and the Court of Appeals or CA. However, litigants do not have unfettered discretion to invoke the court's original jurisdiction. The doctrine of hierarchy of courts dictates that direct recourse to this court is allowed only to resolve questions of law, notwithstanding the invocation of paramount or transcendental importance of the action. This doctrine is not mere policy, rather, it is a constitutional filtering mechanism, designed to enable the court to focus on the more fundamental and essential tasks assigned to it by the highest law of the land. On December 15, 2014, the Department of Transportation and Communication or DOTC and its attached agency, the Civil Aviation Authority of the Philippines or CAAP, posted an invitation to pre-qualify and bid, which will be referred hereinafter as invitation, on the airport development, operations, and maintenance of the Bacolod-Silay, Davao, Iloilo, Lagandingan, New Bohol and Panglaon, and Puerto Princesa airports, collectively referred as projects. The total cost of the projects is 116.23 billion pesos, broken down as follows. The cost for Bacolod-Silay is 20.26 billion pesos. For Davao, it is 40.57 billion pesos. For Iloilo, it is 30.4 billion pesos. For Lagandingan, the amount is 14.62 billion pesos. For New Bohol and Panglao, it is 4.57 billion pesos. And for Puerto Princesa, the cost is 5.81 billion pesos. A total of 116.23 billion pesos. The invitation stated that the projects aim to improve services, and enhance the airside and landside facilities of the key regional airports, through concession agreements with the private sector. The projects will be awarded through competitive bidding, following the procurement rules and procedure prescribed under Republic Act No. 6957, as amended by RN No. 7718, the BOT law, and its implementing rules and regulations. The concession period would be for 30 years. On March 10, 2015, the DOTC and the CAAP issued the instructions to prospective bidders or ITPB, which provided that prospective bidders are to pre-qualify and bid for the development, operations, and maintenance of the airports, which are now bundled into two groups, collectively referred as the bundled projects, namely Bundle 1. Bacolod-Silay and Iloilo. Bundle 2. Davao, Lagandingan, and New Bohol in Panglao. The cost of Bundle 1 and Bundle 2 are 50.66 billion pesos, and 59.66 billion pesos, respectively. The Puerto Princesa Airport project was not included in the bundling. The general procedure for the bidding of the bundled projects stated that prospective bidders may bid for only Bundle 1 or Bundle 2, or bid for both Bundle 1 and Bundle 2. The Prequalification, Bids and Awards Committee or PBAC, shall announce in a bid bulletin prior to the qualification submission date, its policy on whether a prospective bidder may be awarded both bundles, or whether a prospective bidder may only be awarded with one bundle. The submission of the pre-qualification queries was scheduled for April 3, 2015, and the submission of qualification documents on May 18, 2015. On March 27, 2015, petitioner Gios-Samar Incorporated, represented by its chairperson Gerardo M. Malinao, petitioner, suing as a taxpayer, and invoking the transcendental importance of the issue, filed the present petition for prohibition. Petitioner alleges that it is a non-governmental organization, composed of subsistence farmers and fisherfolk from Samar, who are among the victims of Typhoon Yolanda, relying on government assistance for the rehabilitation of their industry and livelihood. It assails the constitutionality of the bundling of the projects, and seeks to enjoin the DOTC and the CAUP from proceeding with the bidding of the same. Petitioner raises the following arguments. First, the bundling of the projects violated the constitutional prohibitions on the anti-dummy, and the grant of opportunity to the general public to invest in public utilities, citing Section 11, Article 12 of the 1987 Constitution. According to petitioner, bundling would allow companies with questionable or shaky financial background, to have direct access to the projects, by simply joining a consortium, which under the bundling scheme adopted by the DOTC, said projects taken all together, would definitely be beyond the financial capability of any qualified, single Filipino corporation. Second, bundling violates the constitutional prohibition on monopolies under Section 19, Article 12 of the Constitution, because it would allow one winning bidder to operate and maintain several airports, thus establishing a monopoly. Petitioner asserts that, given the staggering cost of the bundled projects, the same can only be undertaken by a group, joint venture outfits, and consortiums which are susceptible to combinations and schemes to control the operation of the service for profit, enabling a single consortium to control as many as 6 airports. Third, bundling will surely perpetrate an undue restraint of trade. Mid-sized Filipino companies, which may have previously considered participating in one of the 6 distinct projects, will no longer have a realistic opportunity to participate in the bidding, because the separate projects became 2 gargantuan projects. This effectively placed the projects, beyond the reach of medium-sized Filipino companies. Fourth, the PBAC of the DOTC, committed grave abuse of discretion amounting to excessive jurisdiction when it bundled the projects without legal authority. Fifth, bundling made a mockery of public bidding, because it raised the reasonable bar to a level, higher than what it would have been, had the projects been bidded out separately. In support of petitioner's prayer, for the issuance of a temporary restraining order and/or writ of preliminary injunction, it states that there is extreme urgency to enjoin the bidding of the bundled projects, so as not to cause irreparable damage and injury to the coffers of the government. In its comment, the DOTC counters that 1. The petition is premature, because there has been no actual bidding yet, hence there is no justiciable controversy to speak of. 2. Petitioner has no legal standing to file the suit, whether as a taxpayer or as a private individual. 3. Petitioner's allegation on the violation of anti-dummy and equal opportunity clauses of the Constitution, are speculative and conjectural. 4. Section 11, Article 12 of the Constitution is not applicable to the bidding process assailed by petitioner. 5. The bundling of the projects, does not violate the prohibitions on monopolies or combinations in restraint of trade. And 6. The DOTC and the CAUP, did not commit grave abuse of discretion amounting to lack or excessive jurisdiction. For its part, the CAUP asserts that the petition, violated the basic fundamental principle of hierarchy of courts. Petitioner had not alleged any special and compelling reason, to allow it to seek relief directly from the court. The case should have been filed with the trial court, because it raises factual issues which need to be threshed out in a full-blown trial. The CAUP also maintains that petitioner has neither legal capacity nor authority to file the suit, and that the petition has no cause of action. In its reply, petitioner argues that it need not wait for the conduct of the bidding to file the suit, because doing so would render useless the very purpose for filing the petition for prohibition. As it is, 5 groups have already been pre-qualified to bid in the bundled projects. Petitioner also submits that direct recourse to this court is justified, as the matter of prohibiting the bidding process of the illegally bundled projects are matters of public interest and transcendental importance. It further insists that it has legal standing to file the suit through Millennial, its duly authorized representative. The main issue brought to us for resolution is whether the bundling of the projects is constitutional. Petitioner argues that the bundling of the projects is unconstitutional, because it will 1. Create a monopoly. 2. Allow the creation and operation of a combination in restraint of trade. 3. Violate anti-dummy laws, and statutes giving citizens the opportunity to invest in public utilities, and 4. Enable companies with shaky financial backgrounds, to participate in the projects. 1. While petitioner asserts that the foregoing arguments involve legal, as opposed to factual issues, our examination of the petition shows otherwise. As will be demonstrated shortly, petitioner's arguments against the constitutionality of the bundling of the projects are inextricably intertwined with underlying questions of fact, the determination of which require the reception of evidence. This court, however, is not a trier of fact. We cannot resolve these factual issues at the first instance. For this reason, we dismiss the petition. A. Petitioner claims that the bundling of the projects violates the constitutional provisions on monopolies and combinations in restraint of trade under Section 19, Article 12 of the Constitution, which reads: Section 19. The state shall regulate or prohibit monopolies, while the public interest so requires. No combinations in restraint of trade or unfair competition shall be allowed. In Tat vs. Secretary of the Department of Energy, we clarified that the Constitution does not prohibit the operation of monopolies per se. With particular respect to the operation of public utilities or services, this court, in Anglo-Phil Trading Corporation vs. Lassero, further clarified that, by their very nature, certain public services or public utilities such as those which supply water, electricity, transportation, telephone, telegraph, etc. must be given exclusive franchises if public interest is to be served. Such exclusive franchises are not violative of the law against monopolies. In short, we find that the grant of a concession agreement to an entity, as a winning bidder, for the exclusive development, operation, and maintenance of any or all of the projects, does not by itself create a monopoly violative of the provisions of the Constitution. Anglo-Phil Trading Corporation teaches that exclusivity is inherent in the grant of a concession to a private entity to deliver a public service, where government chooses not to undertake such service. Otherwise stated, while the grant may result in a monopoly, it is a type of monopoly not violative of law. This is the essence of the policy decision of the government, to enter into concessions with the private sector to build, maintain and operate what would have otherwise been government-operated services, such as airports. In any case, the law itself provides for built-in protections to safeguard the public interest, foremost of which is to require public bidding. Under the BOT law, for example, a private-public partnership or PPP agreement may be undertaken through public bidding, in cases of solicited proposals, or through Swiss challenge, also known as comparative bidding, in cases of unsolicited proposals. In any event, the Constitution provides that the state may, by law, prohibit or regulate monopolies when the public interest so requires. Petitioner has failed to point to any provision in the law, which specifically prohibits the bundling of bids, a detail supplied by the respondent DOTC as implementing agency for the PPP program for airports. Our examination of the petition and the relevant statute, in fact, provides further support for the dismissal of the present action. Originally, monopolies and combinations in restraint of trade were governed by, and penalized under Article 186 of the Revised Penal Code. This provision has since been repealed by RA No. 10667, or the Philippine Competition Act, which defines and penalizes all forms of anticompetitive agreements, abuse of dominant position, and anticompetitive mergers and acquisitions. RA number 10667 does not define what constitutes a monopoly. Instead, it prohibits one or more entities which has or have acquired or achieved a dominant position in a relevant market, from abusing its dominant position. In other words, an entity is not prohibited from, or held liable for prosecution and punishment for, simply securing a dominant position in the relevant market in which it operates. It is only when that entity engages in conduct, in abuse of its dominant position, that it will be exposed to prosecution and possible punishment. Under RA number 10667, dominant position is defined as follows. Section 4. Definition of terms. As used in this Act. G. Dominant position refers to a position of economic strength that an entity or entities hold, which makes it capable of controlling the relevant market independently, from any or a combination of the following: competitors, customers, suppliers, or consumers. Relevant market, on the other hand, refers to the market in which a particular good or service is sold, and which is a combination of the relevant product market, and the relevant geographic market. The determination of a particular relevant market depends on the consideration of factors which affect the substitutability among goods or services constituting such market, and the geographic area delineating the boundaries of the market. An entity with a dominant position in a relevant market is deemed to have abused its dominant position if it engages in a conduct that would substantially prevent, restrict, or lessen competition. Here, petitioner has not alleged ultimate facts to support its claim that bundling will create a monopoly, in violation of the Constitution. By merely stating legal conclusions, petitioner did not present any sufficient allegation, upon which the court could grant the relief petitioner prayed for. In Zuniga-Santos v. Santos-Gran, we held that, a pleading should state the ultimate facts essential to the rights of action or defense asserted, as distinguished from mere conclusions of fact, or conclusions of law. General allegations that a contract is valid or legal, or is just, fair, and reasonable, are mere conclusions of law. Likewise, allegations that a contract is void, voidable, invalid, illegal, ultra vires, or against public policy, without stating facts showing its invalidity, are mere conclusions of law. The present action should thus be dismissed, on the ground of failure to state cause of action. Similarly, RA number 10667 does not define what a combination in restraint of trade is. What it does, is penalize anticompetitive agreements. Agreement refers to any type of form or contract, arrangement, understanding, collective recommendation, or concerted action, whether formal or informal. The following agreements are considered anti-competitive. Section 14. Anti-competitive agreements. A. The following agreements, between or among competitors, are per se prohibited. 1. Restricting competition as to price, or components thereof, or other terms of trade. 2. Fixing price at an auction or in any form of bidding including cover bidding, bid suppression, bid rotation and market allocation, and other analogous practices of bid manipulation. B. The following agreements, between or among competitors which have the object or effect of substantially preventing, restricting or lessening competition, shall be prohibited. 1. Setting, limiting, or controlling production, markets, technical development, or investment. 2. Dividing or sharing the market, whether by volume of sales or purchases, territory, type of goods or services, buyers or sellers or any other means. C. Agreements other than those specified in A and B of this section, which have the object or effect of substantially preventing, restricting or lessening competition, shall also be prohibited. Provided, those which contribute to improving the production or distribution of goods and services, or to promoting technical or economic progress, while allowing consumers a fair share of the resulting benefits, may not necessarily be deemed a violation of this Act. An entity that controls, is controlled by, or is under common control with another entity or entities, have common economic interests, and are not otherwise able to decide or act independently of each other, shall not be considered competitors for purposes of this section. The bundling of the projects, is an arrangement made by the DOTC and the COB in the conduct of public bidding. The question that arises, is whether the same constitutes an anti-competitive agreement prohibited by RA number 10667. However, to resolve this, we refer to the factors enumerated in Section 26 of RA number 10667 on the determination of anti-competitive agreements or conduct. Section 26. Determination of anti-competitive agreement or conduct. In determining whether anti-competitive agreement or conduct has been committed, the Commission shall a. Define the relevant market, allegedly affected by the anti-competitive agreement or conduct, following the principles laid out in Section 24 of this chapter. b. Determine if there is actual, or potential adverse impact on competition in the relevant market, caused by the alleged agreement or conduct, and if such impact is substantial, and outweighs the actual or potential efficiency gains that result from the agreement or conduct. c. Adopt a broad and forward-looking perspective, recognizing future developments, any overriding need to make the goods or services available to consumers, the requirements of large investments in infrastructure, the requirements of law, and the need of our economy to respond to international competition, but also taking account of past behavior of the parties involved, and prevailing market conditions. d. Balance the need to ensure that competition is not prevented, or substantially restricted, and the risk that competition efficiency, productivity, innovation, or development of priority areas or industries in the general interest of the country may be deterred by overzealous or undue intervention. And e. Assess the totality of evidence on whether it is more likely than not, that the entity has engaged in anti-negation competitive agreement, or conduct, including whether the entity's conduct was done with a reasonable commercial purpose, such as but not limited to phasing out of a product or closure of a business, or as a reasonable commercial response to the market entry, or conduct of a competitor. Similar to its assertion that bundling will create a monopoly prohibited by law, we find that petitioner, again, utterly failed to sufficiently state a cause of action, by failing to plead ultimate facts to support its conclusion, that bundling, as an arrangement, is in restraint of trade, or results in unfair competition under the provisions of RA number 10667. Even granting that the petition sufficiently pleads a cause of action for the foregoing violations, there is a need to receive evidence to test the premises of petitioner's conclusions. To illustrate, applying the facts and claims relative to the violation of the prescription against monopolies, what RA number 10667, in fact, prohibits and punishes is the situation where 1. An entity, having been granted an exclusive franchise to maintain and operate one or more airports, attains a dominant position in that market. And 2. Abuses such dominant position by engaging in prohibited conduct, for example, acts that substantially prevent, restrict or lessen competition in market of airport development, operations and maintenance. Thus, for petitioner to succeed in asserting that such a prohibited situation legally obtains, it must first establish, by evidence, that indeed 1. The relevant market is that of airport development, maintenance, and operation, under the facts-based criteria enumerated in Section 24 of RA number 10667. 2. The entity has achieved a dominant position, under the facts-based criteria enumerated in Section 27 of RA number 10667 in that relevant market. And 3. The entity commits acts constituting abuse of dominant position, under the facts-based criteria enumerated in Section 27 of RA number 10667. In addition, To support the legal conclusion that bundling is an anti-competitive agreement, there must be evidence that 1. The relevant market is that of airport development, maintenance, and operation, under the facts-based criterion enumerated in Section 24 of RA No. 1066-7. 2. Bundling causes, or will cause, actual or potential adverse impact on the competition in that relevant market. 3. Said impact is substantial, and outweighs the actual or potential efficiency gains that results from bundling, and 4. The totality of evidence shows that the winning bidder, more likely than not, engaged in anti-competitive conduct. The court, however, is still not a trier of facts. Petitioner should have brought the challenge before a tribunal, specially equipped to resolve the factual and legal issues presented. B. We now jointly discuss petitioner's remaining allegations, namely, that bundling of the projects 1. Violates the anti-dummy law and the constitutional provision, allegedly giving citizens the opportunity to invest in public utilities. 2. Is in grave abuse of discretion, and 3. Enables companies with shaky financial backgrounds, to participate in the projects. Commonwealth Act No. 108, as amended, otherwise known as the Anti-Dummy Law, was enacted to limit the enjoyment of certain economic activities to Filipino citizens or corporations. Section 2 of said law states. Section 2. Simulation of minimum capital stock. In all cases, in which a constitutional or legal provision requires, that in order that a corporation or association may exercise or enjoy a right, franchise or privilege, not less than a certain percentum of its capital, must be owned by citizens of the Philippines, or of any other specific country, it shall be unlawful to falsely simulate the existence of such minimum stock, or capital as owned by such citizens, for the purpose of evading said provision. The President, or managers and directors, or trustees of corporations or associations convicted of a violation of this section, shall be punished by imprisonment, of not less than 5 nor more than 15 years, and by a fine not less than the value of the right, franchise or privilege, enjoyed or acquired in violation of the provisions hereof, but in no case less than 5,000 pesos. For liability for violation of Section 2 to attach, it must first be established, that there is a law limiting or reserving the enjoyment or exercise of a right, franchise, privilege, or business to citizens of the Philippines, or to corporations, or associations at least a certain percentage of which is owned by such citizens. Moreover, it must be shown by evidence, that a corporation or association falsely simulated, the existence of the minimum required Filipino stock or capital ownership to enjoy or exercise the right, franchise, privilege, or business. In this case, petitioner failed to allege ultimate facts, showing how the bundling of the projects violated the anti-dummy law. It did not identify, what corporation or association falsely simulated the composition of its stock ownership. Moreover, it did not allege, that there is a law limiting, reserving, or requiring that infrastructure or development projects must be awarded only to corporations, a certain percentage of the capital of which is exclusively owned by Filipinos. Executive Order or EO No. 65, even exempts contracts for infrastructure or development projects covered by the BOT law from the 40% foreign ownership limitation. For the same reasons above, petitioner's allegation that bundling violated Section 11, Article 12 of the Constitution, which prescribes a 60% Filipino ownership requirement for franchises, certificate, or for the operation of public utilities, must be rejected. Petitioner's argument that, bundling of the projects gave shady companies direct access to the projects, also raises questions of fact. Foremost, petitioner does not identify these shady companies. Even assuming that petitioner is referring to any or all of the 5 companies who have been pre-qualified to bid in the projects, its assertion that these companies are not financially able to undertake the project, raises a question of fact, financial ability, being a prequalification requirement. As already stated earlier, such question is one which this court is ill-equipped to resolve. Finally, the allegation that bundling is in grave abuse of discretion, is a conclusion of law. As shown, no facts were even alleged to show which specific law was violated by the decision to bundle the projects. In short, these three above arguments of petitioner, must be dismissed for failure to sufficiently plead a cause of action. Even assuming that petitioner's causes of action were properly alleged, the resolution of said issues would still require the determination of factual issues, which this court simply cannot undertake. In fine, while this court has original and concurrent jurisdiction with the RTC and the CA, in the issuance of writs of certiorari, prohibition, mandamus, quo warranto, and habeas corpus which are extraordinary writs, direct recourse to this court is proper only to seek resolution of questions of law. Save for the single specific instance provided by the Constitution under Section 18, Article 7, cases, the resolution of which depends on the determination of questions of fact, cannot be brought directly before the court, because we are not a trier of facts. We are not equipped, either by structure or rule, to receive and evaluate evidence in the first instance. These are the primary functions of the lower courts or regulatory agencies. This is the raison d'etre behind the doctrine of hierarchy of courts. It operates as a constitutional filtering mechanism, designed to enable this court to focus on the more fundamental tasks assigned to it by the Constitution. It is a bright line rule, which cannot be brushed aside by an invocation of the transcendental importance, or constitutional dimension of the issue or cause raised. 2. For a better understanding of our ruling today, we review below, in light of the court's fundamental constitutional tasks, the constitutional and statutory evolution of the court's original and concurrent jurisdiction, and its interplay with related doctrines, pronouncements, and even the court's own rules, as follows. A. The court's original and concurrent jurisdiction. B. Direct recourse to the court under the Ungara model. C. The Transcendental Importance Doctrine. D. The court is not a trier of facts. E. The doctrine of hierarchy of courts. F. The court's expanded jurisdiction, social rights, and the court's constitutional rulemaking power under the 1987 Constitution. G. Exceptions to the doctrine of hierarchy of courts. The case of, the Diocese of Bucco-Lud vs. Commission on Elections. H. Hierarchy of courts as a constitutional imperative. And I. Hierarchy of courts as a filtering mechanism. A. The court's original and concurrent jurisdiction. The Supreme Court's original jurisdiction, over petitions for extraordinary writs, predates the 1935 Constitution. On June 11, 1901, the Second Philippine Commission, popularly known as the Taft Commission, enacted Act No. 136, or an act providing for the organization of courts in the Philippine Islands. Act No. 136, vested the judicial power of the government of the Philippine Islands unto the Supreme Court, Courts of First Instance or CFI, Courts of Justices of the Peace, together with such special jurisdiction of municipal courts, and other special tribunals as may be authorized by law. Under Act No. 136, the Supreme Court had original jurisdiction over the following cases. Section 17. Its original jurisdiction. The Supreme Court shall have original jurisdiction to issue writs of mandamus, certiorari, prohibition, habeas corpus, and quo warranto in the cases, and in the manner prescribed in the Code of Civil Procedure, and to hear and determine controversies thus brought before it, and in other cases provided by law. The Code of Civil Procedure or the 1901 Rules, referred to in Section 17 of Act No. 136, in turn, provided that the Supreme Court shall have concurrent jurisdiction with the CFIs in certiorari, prohibition, and mandamus proceedings, over any inferior tribunal, board, or officer, and in quo warranto and habeas corpus proceedings. Likewise, the 1901 rule stated, that the court shall have original jurisdiction by certiorari and mandamus over the proceedings of CFIs wherever said courts have acted without, or in excess of jurisdiction, or in case of a mandamus proceeding, when the CFIs and judges thereof, unlawfully neglect the performance of a duty imposed by law. Notably, Sections 496 and 497 of the 1901 rules prescribe the court, not only from reviewing the evidence taken in the court below, but also from retrying questions of fact, namely. Section 496. General Procedure in the Supreme Court. The Supreme Court may, in the exercise of its appellate jurisdiction, affirm, reverse, or modify any final judgment, order, or decree of a court of first instance, regularly entered in the Supreme Court by bill of exceptions, or appeal, and may direct the proper judgment, order, or decree to be entered, or direct a new trial, or further proceedings to be had, and if a new trial shall be granted, the court shall pass upon and determine all the questions of law involved in the case presented by such bill of exceptions and necessary for the final determination of the action. Section 497. Hearings confined to matters of law, with certain exceptions. In hearings upon bills of exception, in civil actions and special proceedings, the Supreme Court shall not review the evidence taken in the court below, nor retry the questions of fact, except as in this section hereafter provided. But shall determine only questions of law raised by the bill of exceptions. On July 1, 1902, the Congress enacted the Philippine Bill, or the first Constitution of the Philippines under the American occupation. The Philippine Bill retained original jurisdiction of the Supreme Court conferred under Act No. 136, with the caveat that the Legislative Department might add to such jurisdiction. Thus, in Weigel v. Schuster, one of the earliest cases of the court, we held that the Philippine Commission could increase, but not decrease, our original jurisdiction under Act No. 136. On December 31, 1916, Act No. 2657 or the Administrative Code was enacted, which included the judiciary law under Title IV, Chapter 10. It was revised on March 10, 1917 through the revised Administrative Code, which increased the original jurisdiction of the Supreme Court, by adding those cases affecting ambassadors, other public ministers, and consuls. On May 14, 1935, 33 years after the enactment of the Philippine Bill, the Philippines ratified the 1935 Constitution. Like its predecessor, the 1935 Constitution adopted the original jurisdiction of the Supreme Court as provided in existing laws, for example, Act No. 136, the 1901 rules, and the revised Administrative Code. Section 3, Article A of the 1935 Constitution states that, until the Congress shall provide otherwise, the Supreme Court shall have such original and appellate jurisdiction, as may be possessed and exercised by the Supreme Court of the Philippine Islands at the time of the adoption of this Constitution. The 1935 Constitution further stated that the Congress may not deprive the Supreme Court of its original jurisdiction over cases affecting ambassadors, other public ministers, and consuls. On December 31, 1935, Commonwealth Act No. 3, amending the revised Administrative Code, created the Court of Appeals or CA, and granted it original jurisdiction to issue writs of mandamus, prohibition, injunction, certiorari, habeas corpus, and all other auxiliary writs and process in aid of its appellate jurisdiction. On June 17, 1948, the Congress enacted RA No. 296, otherwise known as the Judiciary Reorganization Act of 1948. Section 17 of RA No. 296, vested the Supreme Court with original and exclusive jurisdiction in petitions for the issuance of writs of certiorari, prohibition and mandamus against the Court of Appeals. It also provided that the Supreme Court shall exercise original and concurrent jurisdiction with CFIs. 1. In petitions for the issuance of writs of certiorari, prohibition, mandamus, quo warranto, and habeas corpus. 2. In actions between the Roman Catholic Church and the municipalities or towns, or the Filipino Independent Church for controversy as to Title II, or ownership, administration or possession of hospitals, convents, cemeteries or other properties used in connection therewith. 3. In actions brought by the government of the Philippines against the Roman Catholic Church or vice versa, for the Title II, or ownership of hospitals, asylums, charitable institutions, or any other kind of property. And 4. In actions brought to prevent and restrain violations of law concerning monopolies and combinations in restraint of trade. RA number 5440 amended RA number 296 on September 9, 1968, deleting numbers 3 and 4 mentioned above. Several years later, on January 17, 1973, the Philippines ratified the 1973 Constitution. Article 10 of the same is dedicated to the judiciary. Section 5 paragraph 1 of the said article, provides for the Supreme Court's original jurisdiction, namely. Section 5. The Supreme Court shall have the following powers. 1. Exercise original jurisdiction over cases affecting ambassadors, other public ministers and consuls, and over petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. Where the 1935 Constitution only referred to the original jurisdiction which the Supreme Court possessed at the time of its adoption, the 1973 Constitution expressly provided for the Supreme Court's original jurisdiction over petitions for the issuance of extraordinary writs. In 1981, this court's original jurisdiction over extraordinary writs became concurrent with the CA, pursuant to Batas Pambansa Bilang 129 or BP 129, or the Judiciary Reorganization Act of 1980. BP 129 repealed RA number 296, and granted the CA with original jurisdiction, to issue writs of mandamus, prohibition, certiorari, habeas corpus, and quo warranto, and auxiliary writs or processes, whether or not in aid of its appellate jurisdiction. In addition, Section 21 paragraph 2 of BP 129, bestowed the RTCs, formerly the CFIs with original and consequently, concurrent with the Supreme Court, jurisdiction over actions affecting ambassadors and other public ministers and consuls. 7 years after the enactment of BP 129, the Philippines ratified the 1987 Constitution. Article 7, Section 5 paragraph 1, of which provides the original jurisdiction of the Supreme Court, which is an exact reproduction of Section 5 paragraph 1, Article 10 of the 1973 Constitution. B. Direct recourse to the court under the Angara model. Direct invocation of the court's original jurisdiction over the issuance of extraordinary writs, started in 1936 with Angara v. Electoral Commission. Angara is the first case directly filed before the court after the 1935 Constitution took effect on November 15, 1935. It is the quintessential example of a valid direct recourse to this court on constitutional questions. Angara was an original petition for prohibition, seeking to restrain the Electoral Commission from taking further cognizance of an election contest, led against an elected and confirmed member of the National Assembly. The main issue before the court, involved the question of whether the Supreme Court had jurisdiction, over the Electoral Commission and the subject matter of the controversy. We took cognizance of the petition, ruling foremost that the court has jurisdiction over the case, by virtue of its power of judicial review under the Constitution. When the judiciary mediates, to allocate constitutional boundaries, it does not assert any superiority over the other departments, it does not in reality nullify or invalidate an act of the legislature, but only asserts the solemn and sacred obligation assigned to it by the Constitution, to determine conflicting claims of authority under the Constitution, and to establish for the parties in an actual controversy, the rights which that instrument secures, and guarantees to them. In Angara, there was no dispute as to the facts. Petitioner was allowed to file the petition for prohibition directly before us, because what was considered was the nature of the issue involved in the case. A legal controversy between two agencies of the government, that called for the exercise of the power of judicial review by the final arbiter of the Constitution, the Supreme Court. Several years later, another original action for prohibition was filed directly before the court, this time seeking to enjoin certain members of the rival political party, from continuing to usurp, intrude into and/or hold, or exercise the said public offices, respectively being occupied by them in the Senate Electoral Tribunal. In Tanyada, and Macapagal vs. Cuenco, et al. We were confronted with the issue of whether the election of Senators Cuenco and Delgado, by the Senate, as members of the Senate Electoral Tribunal, upon nomination by Senator Primicias, a member and spokesman of the party having the largest number of votes in the Senate, on behalf of its Committee on Rules, contravenes the constitutional mandate, that said members of the Senate Electoral Tribunal, shall be chosen upon nomination of the party having the second largest number of votes. There, this court proceeded to resolve the constitutional issue raised, without inquiring into the propriety of direct recourse to us. Similar with Angara, the question before us, then, was purely legal. The Angara model of direct recourse, would be followed and allowed by the court in Bangzon Jr. vs. Senate Blue Ribbon Committee. Francisco Jr. vs. Nug Mamalasakit Incorporated. Province of North Cotabato vs. Government of the Republic of the Philippines Peace Panel on Ancestral Domain or GRP. McAllental vs. Presidential Electoral Tribunal. Bel Hica vs. Ochoa. Imbong vs. Ochoa Jr. Ara Ulio vs. Aquino III. Sagasag vs. Ochoa Jr. Padilla vs. Congress of the Philippines, to name a few. To stress, the common denominator of all these cases is that the threshold questions presented before us are ones of law. C. The Transcendental Importance Doctrine. In 1949, the court introduced a legal concept, that will later underpin most of the cases filed directly before us. The doctrine of transcendental importance. Although this doctrine was originally used to relax the rules on locus standi or legal standing, its application would later be loosely extended as an independent justification for direct recourse to this court. We first used the term, transcendental importance, in Araneta vs. Dinglasan. Araneta involved 5 consolidated petitions before the court, assailing the validity of the President's orders issued pursuant to Commonwealth Act No. 671, or an act declaring a state of total emergency as a result of war involving the Philippines, and authorizing the President to promulgate rules and regulations to meet such emergency. Petitioners rested their case on the theory that, Commonwealth Act No. 671 had already ceased to have any force and effect. The main issues for resolution in Araneta were: 1. Whether Commonwealth Act No. 671 was still in force. And relatedly. 2. Whether the executive orders issued pursuant thereto were valid. Specifically, the court had to resolve the issue of whether Commonwealth Act No. 671 and the President's emergency powers, continued to be effective after the opening of the regular session of Congress. In overruling the objection to the personality or sufficiency of the interest of petitioners in bringing the actions as taxpayers, this court declared that, above all, the transcendental importance to the public of these cases, demands that they be settled promptly and definitely, brushing aside, if we must, technicalities of procedure. Thus, and similar with Angara, direct recourse to the court in Araneta is justified, because the issue to be resolved was one of law, there was no dispute as to any underlying fact. Araneta has since then been followed by a myriad of cases, where transcendental importance was cited as basis for setting aside objections on legal standing. It was in Chavez v. Public Estates Authority when, for the first time, it appeared that the Transcendental Importance Doctrine could, apart from its original purpose to overcome objections to stand as a justification for disregarding the prescription against direct recourse to the court. Chavez is an original action for mandamus filed before the Court against the Public Estates Authority or PEA. There, the petition sought, among others, to compel the PEA to disclose all facts on the PEA's then ongoing renegotiations to reclaim portions of Manila Bay. On the issue of whether the non-observance of the hierarchy of courts merits the dismissal of the petition, we ruled that the principle of hierarchy of courts applies generally to cases involving factual questions. As it is not a trier of facts, the court cannot entertain cases involving factual issues. The instant case, however, raises constitutional issues of transcendental importance to the public. The court can resolve this case without determining any factual issue related to the case. Also, the instant case is a petition for mandamus which falls under the original jurisdiction of the court under Section 5, Article 8 of the Constitution. We resolve to exercise primary jurisdiction over the instant case. D. The court is not a trier of facts. In 1973, the dictum that the Supreme Court is not trier of facts, first appeared in jurisprudence, through the concurring opinion of then Chief Justice Caraby Macalintal in Complex Philippines Incorporated v. Petition. Complex involved a petition for certiorari against an order recognizing the validity and legitimacy of the election of directors on the board of a private corporation. In his concurrence to the majority decision dismissing the petition, Chief Justice Caraby Macalintal wrote, Judge Petition issued the order now assailed herein, after he heard the parties and received relevant evidence bearing on the incident before him, namely, the issuance of a writ of preliminary injunction as prayed for by the defendants. He issued the writ on the basis of the facts as found by him, subject of course, as he himself admitted, considering the interlocutory nature of the injunction, to further consideration of the case on the merits after trial. I do not see that his factual findings are arbitrary or unsupported by the evidence. If anything, they are circumspect, reasoned out and arrived at after serious judicial inquiry. This court is not a trier of facts, and it is beyond its function to make its own findings of certain vital facts different from those of the trial court, especially on the basis of the conflicting claims of the parties, and without the evidence being properly before it. For this court to make such factual conclusions is entirely unjustified. First, because if material facts are controverted, as in this case, and they are issues being litigated before the lower court, the petition for certiorari would not be in aid of the appellate jurisdiction of this court. And, secondly, because it preempts the primary function of the lower court, namely, to try the case on the merits, receive all the evidence to be presented by the parties, and only then come to a definite decision, including either the maintenance or the discharge of the preliminary injunction it has issued. The thousands of pages of pleadings, memoranda, and annexes already before this court, and the countless hours spent in discussing the bare allegations of the parties, as to the factual aspects of which the members are in sharp disagreement, merely to resolve whether or not to give due course to the petition, demonstrate clearly why this court, in a case like this, should consider only one question, and no other, namely, did the court below commit a grave abuse of discretion in issuing the order complained of? And should answer that question without searching the pleadings for supposed facts still in dispute, and not those set forth in the order itself, and in effect deciding the main case on the merits, although it is yet in its preliminary stages, and has not entered the period of trial. The maxim that the Supreme Court is not a trier of facts, will later find its way in the court's majority opinion in Mafinco Trading Corporation v. Opla. Mafinco involved a special civil action for certiorari and prohibition, to annul a decision of the Secretary of Labor, finding that the old National Labor Relations Commission or NLRC, had jurisdiction over the complaint filed against Mafinco Trading Corporation, for having dismissed 2 union members. The crucial issue brought before the court, was whether an employer-employee relationship existed between petitioner and the private respondents. Before resolving the issue on the basis of the parties' contracts, the court made the following pronouncements. The parties in their pleadings and memoranda injected conflicting factual allegations to support their diametrically opposite contentions. From the factual angle, the case has become highly controversial. In a certiorari and prohibition case, like the instant case, only legal issues affecting the jurisdiction of the tribunal, board or officer involved, may be resolved on the basis of undisputed facts. Sections 1, 2 and 3, Rule 65 of the Rules of Court, require that in the verified petition for certiorari, mandamus and prohibition, the petitioner should allege facts with certainty. In this case, the facts have become uncertain. Controversial evidentiary facts have been alleged. What is certain and indubitable is that a notarized peddling contract was executed. This court is not a trier of facts. It would be difficult, if not anomalous, to decide the jurisdictional issue on the basis of the parties' contradictory factual submissions. The record has become voluminous, because of their efforts to persuade this court to accept their discordant factual statements. Pro hoc vici, the issue of whether Repo Manta and Meralda were employees of Mafinco, or were independent contractors, should be resolved mainly in the light of their peddling contracts. A different approach would lead this court astray, into the field of factual controversy, where its legal pronouncements would not rest on solid grounds. The Rules of Court referred to above, is the 1964 Rules of Court. Up to this date, the requirement of alleging facts with certainty, remains in sections 1 to 3 of Rule 65 of the 1997 Revised Rules of Court. Meanwhile, the court, aware of its own limitations, decreed in Section 2, Rule 3 of its internal rules that it is not a trier of facts, viz. Section 2. The court, not a trier of facts. The court is not a trier of facts, its role is to decide cases based on the findings of fact before it. Where the Constitution, the law or the court itself, in the exercise of its discretion, decides to receive evidence, the reception of evidence may be delegated to a member of the court, to either the clerk of court, or one of the division clerks of court, or to one of the appellate courts or its justices, who shall submit to the court a report and recommendation on the basis of the evidence presented. E. The doctrine of hierarchy of courts. Starting in 1987, the court, in 2 cases, addressed the penchant of litigants to seek direct recourse to it, from decisions originating even from the municipal trial courts and city courts. In Vergara, Sr. vs. Suelto, the court's original jurisdiction over special civil actions for mandamus was invoked, to compel a municipal trial court or MTC to issue summary judgment in a case for a legal detainer. There, we declared in no uncertain terms that, as a matter of policy, such a direct recourse to this court, should not be allowed. The Supreme Court is a court of last resort, and must so remain, if it is to satisfactorily perform the functions assigned to it by the fundamental charter and immemorial tradition. It cannot and should not be burdened, with the task of dealing with causes in the first instance. Its original jurisdiction to issue the so-called extraordinary writs, should be exercised only where absolutely necessary, or where serious and important reasons exist therefor. Hence, that jurisdiction should generally be exercised, relative to actions or proceedings before the Court of Appeals, or before constitutional or other tribunals, bodies or agencies, whose acts for some reason or another, are not controllable by the Court of Appeals. Where the issuance of an extraordinary writ, is also within the competence of the Court of Appeals or a regional trial court, it is in either of these courts, that the specific action for the writ's procurement must be presented. This is, and should continue to be the policy in this regard, a policy that courts and lawyers must strictly observe. This so-called policy, was reaffirmed 2 years later in People v. Quaresma, which involved a petition for certiorari, challenging the quashal by the city fiscal of an information for defamation on the ground of prescription. In dismissing the petition, this court reminded litigants, to refrain from directly filing petitions for extraordinary writs before the court, unless there were special and important reasons therefor. We then introduce the concept of hierarchy of courts, to wit, this court's original jurisdiction to issue writs of certiorari, as well as prohibition, mundumus, quo warranto, habeas corpus and injunction, is not exclusive. It is shared by this court with regional trial courts, formerly courts of first instance, which may issue the writ, enforceable in any part of their respective regions. It is also shared by this court, and by the regional trial court, with the Court of Appeals, formerly, Intermediate Appellate Court, although prior to the effectivity of Batas Pambansa Bilang 129 on August 14, 1981, the latter's competence to issue the extraordinary writs, was restricted to those, in aid of its appellate jurisdiction. This concurrence of jurisdiction is not, however, to be taken as according to parties seeking any of the writs, an absolute, unrestrained freedom of choice of the court, to which application therefore will be directed. There is after all, a hierarchy of courts. That hierarchy is determinative of the venue of appeals, and should also serve as a general determinant of the appropriate form for petitions for the extraordinary writs. A becoming regard for that judicial hierarchy, most certainly indicates that petitions for the issuance of extraordinary writs against first-level or inferior courts, should be filed with the regional trial court, and those against the latter, with the Court of Appeals. A direct invocation of the Supreme Court's original jurisdiction to issue these writs, should be allowed only when there are special and important reasons therefor, clearly and specifically set out in the petition. This is established policy. The Court feels the need to reaffirm that policy at this time, and to enjoin strict adherence thereto, in the light of what it perceives to be a growing tendency on the part of litigants and lawyers, to have their applications for the so-called extraordinary writs, and sometime even their appeals, passed upon and adjudicated directly and immediately, by the highest tribunal of the land. This doctrine of hierarchy of courts, guides litigants as to the proper venue of appeals, and or the appropriate form for the issuance of extraordinary writs. Thus, although this court, the CA, and the RTC have concurrent original jurisdiction over petitions for certiorari, prohibition, mundumus, quo warranto, and habeas corpus, parties are directed, as a rule, to file their petitions before the lower ranked court. Failure to comply is sufficient cause for the dismissal of the petition. This court has interchangeably referred to the hierarchy of courts as a principle, a rule, and a doctrine. For purposes for this discussion, however, we shall refer to it as a doctrine. F. The court's expanded jurisdiction, social rights, and the court's constitutional rulemaking power under the 1987 Constitution. With the 1987 Philippine Constitution, came significant developments in terms of the court's judicial and rulemaking powers. First, judicial power is no longer confined to its traditional ambit of settling actual controversies, involving rights that were legally demandable and enforceable. The second paragraph of Section 1, Article 8 of the 1987 Constitution provides that judicial power also includes the duty of the courts, to determine whether or not there has been a grave abuse of discretion amounting to lack or excessive jurisdiction, on the part of any branch or instrumentality of the government. In Ara Ulio v. Aquino III, former associate, now Chief Justice Bersamin eruditely explained. The Constitution states that judicial power, includes the duty of the courts of justice, not only to settle actual controversies involving rights which are legally demandable and enforceable, but also to determine whether or not there has been a grave abuse of discretion, amounting to lack or excessive jurisdiction, on the part of any branch or instrumentality of the government. It has thereby expanded the concept of judicial power, which up to then, was confined to its traditional ambit of settling actual controversies, involving rights that were legally demandable and enforceable. With respect to the court, however, the remedies of certiorari and prohibition, are necessarily broader in scope and reach, and the writ of certiorari or prohibition, may be issued to correct errors of jurisdiction, committed not only by a tribunal, corporation, board or officer exercising judicial, quasi-judicial or ministerial functions, but also to set right, undo and restrain any act of grave abuse of discretion, amounting to lack or excessive jurisdiction by any branch or instrumentality of the government, even if the latter does not exercise judicial, quasi-judicial or ministerial functions. This application is expressly authorized by the text of the second paragraph of Section 1, supra. It must be stressed, however, that this grant of expanded power of judicial review, did not result to the abandonment of the Ungara model. Direct recourse to the court, on grounds of grave abuse of discretion, was still allowed only when the questions presented were legal. Second, in addition to providing for, self-executory and ready for use, civil and political rights, the 1987 Constitution also contained provisions pertaining to what has been termed as, social rights. Esteemed constitutionalist and member of the 1987 Constitutional Commission Father Joaquin G. Bernas, S.J., explained. But as will be seen, the 1987 Constitution advances beyond what was in previous constitutions, in that it seeks not only economic social justice, but also political social justice. The guarantees of civil and political rights found principally in the Bill of Rights, are self-executory and ready for use. One can assert those rights in a court of justice. Social rights are a different phenomenon. Except to the extent that they prohibit the government from embarking in activity contrary to the ideals of social justice, they generally are not rights in the strict sense that the rights in the Bill of Rights are. In legal effectiveness, they are primarily in the nature of claims of demands, which people expect government to satisfy, or they are ideals which government is expected to respect. This, in turn, gave rise to a slew of litigation invoking these so-called, social rights. In Oposa versus Factorin Jr., for example, this court famously recognized an enforceable right to a balanced and healthful ecology under Section 16, Article 2 of the 1987 Constitution. Third, the Supreme Court's rulemaking power was enhanced under the new Constitution, to wit. Section 5. The Supreme Court shall have the following powers. Paragraph 5. Promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. Such rules shall provide a simplified and inexpensive procedure for the speedy disposition of cases, shall be uniform for all courts of the same grade, and shall not diminish, increase, or modify substantive rights. Rules of procedure of special courts and quasi-judicial bodies, shall remain effective unless disapproved by the Supreme Court. For the first time, the court was granted with the following. 1. The power to promulgate rules concerning the protection and enforcement of constitutional rights. And 2. The power to disapprove rules of procedure of special courts and quasi-judicial bodies. The 1987 Constitution also took away the power of Congress to repeal, alter, or supplement rules concerning pleading, practice and procedure. Pursuant to its constitutional rulemaking power, the court promulgated new sets of rules which effectively increased its original and concurrent jurisdiction with the RTC and the CA. 1. AM number 07-9-12-SC, or the rule on the writ of amparo. 2. AM number 08-1-16-SC, or the rule on the writ of habeas data. And 3. AM number 09-6-8-SC, or the rules of procedure for environmental cases. Under these rules, litigants are allowed to seek direct relief from this court, regardless of the presence of questions which are heavily factual in nature. In the same vein, judgments and petitions for writ of amparo, writ of habeas data, and writ of cali causam rendered by lower ranked courts, can be appealed to the Supreme Court on questions of fact, or law, or both, via a petition for review on certiorari under Rule 45 of the 1997 Rules of Court. In practice, however, petitions for writ of amparo, writ of habeas data, and writ of Kali Kasan, which were originally filed before this court, invariably found their way to the CA for hearing and decision, with the CA's decision to be later on, brought before us on appeal. Thus, in Secretary of National Defense vs. Manalo, the first ever amparo petition, this court ordered the remand of the case to the CA for the conduct of hearing, reception of evidence, and decision. We also did the same in 1. Rodriguez vs. Macapagal Arroyo. 2. Saez vs. Macapagal Arroyo. And 3. International Service for the Acquisition of Agri-Biotech Applications Incorporated, versus Greenpeace Southeast Asia Philippines. The consistent practice of the court in these cases, that is, referring such petitions to the CA for the reception of evidence, is a tacit recognition by the court itself that it is not equipped to be a trier of facts. Notably, our referral of the case to the CA for hearing, reception of evidence, and decision, is in consonance with Section 2, Rule 3 of our internal rules, which states that if the court, in the exercise of its discretion, decides to receive evidence, it may delegate the same to one of the appellate courts for report and recommendation. G. Exceptions to the doctrine of hierarchy of courts. Aside from the special civil actions over which it has original jurisdiction, the court, through the years, has allowed litigants to seek direct relief from it upon allegation of serious and important reasons. The Diocese of Bacolod vs. Commission on Elections summarize these circumstances in this wise. 1. When there are genuine issues of constitutionality, that must be addressed at the most immediate time. 2. When the issues involved are of transcendental importance. 3. Cases of first impression. 4. The constitutional issues raised are better decided by the court. 5. Exigency in certain situations. 6. The filed petition reviews the act of a constitutional organ. 7. When petitioners rightly claim that they had no other plain, speedy, and adequate remedy in the ordinary course of law, that could free them from the injurious effects of respondents' acts, in violation of their right to freedom of expression. And 8. The petition includes questions that are dictated by public welfare and the advancement of public policy, or demanded by the broader interest of justice, or the orders complained of were found to be patent nullities, or the appeal was considered as clearly an inappropriate remedy. A careful examination of the jurisprudential basis of the foregoing exceptions would reveal a common denominator: the issues for resolution of the court are purely legal. Similarly, the court in Diocese decided to allow direct recourse in said case because, just like Ungara, what was involved was the resolution of a question of law, namely, whether the limitation on the size of the tarpaulin in question violated the right to free speech of the Bacolod bishop. We take this opportunity to clarify that the presence of one or more of the so-called special and important reasons is not the decisive factor considered by the court in deciding whether to permit the invocation, at the first instance, of its original jurisdiction over the issuance of extraordinary writs. Rather, it is the nature of the question raised by the parties in those exceptions that enabled us to allow the direct action before us. As a case in point, we shall focus our discussion on transcendental importance. Petitioner after all argues that its direct resort to us is proper, because the issue raised, that is, whether the bundling of the projects violates the constitutional prescription on monopoly and restraint of trade, is one of transcendental importance, or of paramount public interest. An examination of the cases, wherein this court used transcendental importance of the constitutional issue raised to excuse violation of the principle of hierarchy of courts, would show that resolution of factual issues was not necessary for the resolution of the constitutional issue or issues. These cases include Chavez vs. Public Estates Authority, Agun, Jr. vs. Philippine International Air Terminals Company Incorporated, Jaworski vs. Philippine Amusement and Gaming Corporation, Province of Batangas vs. Romulo. Aquino III vs. Commission on Elections. Department of Foreign Affairs vs. Falcon. Kapalya vs. Commission on Elections. Culayan vs. Tan. Puna vs. Manila Economic and Cultural Office. Ferrer Jr. vs. Bautista. And Ifu Rong vs. Carpio Morales. In all these cases, there were no disputed facts, and the issues involved were ones of law. In Agun, we stated that, the facts necessary to resolve these legal questions are well established and, hence, need not be determined by a trial court. In Jaworski, the issue is whether Presidential Decree No. 1869, authorized the Philippine Amusement and Gaming Corporation, to contract any part of its franchise by authorizing a concessionaire to operate internet gambling. In Romulo, we declared that the facts necessary to resolve the legal question are not disputed. In Aquino III, the lone issue is whether RA No. 9716, which created an additional legislative district for the province of Camarines Sur, is constitutional. In Falcon, the threshold issue is, whether an information and communication technology project, which does not conform to our traditional notion of the term infrastructure, is covered by the prohibition against the issuance of court injunctions under RA No. 8975. Similarly, in Kapalya, the issue is the validity and constitutionality of the Commission on Elections resolutions for the purchase of percent count optical scanner machines, as well as the extension agreement and the deed of sale covering the same. In Culayan, the issue is whether Section 465 in relation to Section 16 of the Local Government Code, authorizes the respondent governor, to declare a state of national emergency, and to exercise the powers enumerated in his Proclamation No. 1-09. In Fu-Na, the issue is whether the Commission on Audit is, under prevailing law, mandated to audit the accounts of the Manila Economic and Cultural Office. In Ferrer, the issue is the constitutionality of the Quezon City ordinances, imposing socialized housing tax and garbage fee. In Ifu Rong, the issue is whether Section 8 Paragraph 3 of RA No. 6770, or the Ombudsman Act of 1989 is constitutional. More recently, in Ala vs. Oy, the Court on Bank, dismissed an original action for certiorari, prohibition, and mundumus, which prayed for the nullification of an ordinance, for violation of the Equal Protection Clause, Due Process Clause, and the rule on uniformity in taxation. We stated that, not only did petitioners therein fail to set forth exceptionally compelling reasons, for their direct resort to the court, they also raised factual issues which the court deems indispensable for the proper disposition of the case. We reiterated the time-honored rule that we are not a trier of facts. The initial reception and appreciation of evidence are functions that the court cannot perform. These are functions best left to the trial courts. To be clear, the Transcendental Importance Doctrine does not clothe us with the power to tackle factual questions and play the role of a trial court. The only circumstance when we may take cognizance of a case in the first instance, despite the presence of factual issues, is in the exercise of our constitutionally expressed task, to review the sufficiency of the factual basis of the President's proclamation of martial law under Section 18, Article 7 of the 1987 Constitution. The case before us, does not fall under this exception. H. Hierarchy of courts is a constitutional imperative. Strict observance of the doctrine of hierarchy of courts, should not be a matter of mere policy. It is a constitutional imperative given 1. The structure of our judicial system and 2. The requirements of due process. First, the doctrine of hierarchy of courts recognizes the various levels of courts in the country as they are established under the Constitution and by law, their ranking and effect of their rulings in relation with one another, and how these different levels of court interact with one another. It determines the venues of appeals, and the appropriate forum for the issuance of extraordinary writs. Since the creation of the court in 1901, and save for certain exceptions, it does not, as a rule, retry questions of facts. Trial courts such as the MTCs and the RTCs, on the other hand, routinely decide questions of fact and law at the first instance, in accordance with the jurisdiction granted to them by law. While the CA and other intermediate courts can rule on both questions of fact and law, the Supreme Court, in stark contrast, generally decides only questions of law. This is because the court, whether in the exercise of its original or appellate jurisdiction, is not equipped to receive and evaluate evidence in the first instance. Our sole role is to apply the law based on the findings of facts brought before us. Notably, from the 1901 rules until the present 1997 revised rules of court, the power to ascertain facts and receive and evaluate evidence in relation thereto, is lodged with the trial courts. In Alonzo v. Cebu Country Club Incorporated, this court had occasion to articulate the role of the CA in the judicial hierarchy, viz. The hierarchy of courts is not to be lightly regarded by litigants. The CA stands between the RTC and the court, and its establishment has been precisely to take over much of the work that used to be done by the court. Historically, the CA has been of the greatest help to the court in synthesizing the facts, issues, and rulings in an orderly and intelligible manner, and in identifying errors that ordinarily might escape detection. The court has thus been freed to better discharge its constitutional duties, and perform its most important work, which, in the words of Dean Vicente G. Cinco, is less concerned with the decision of cases that begin and end with the transient rights and obligations of particular individuals, but is more intertwined with the direction of national policies, momentous economic and social problems, the delimitation of governmental authority, and its impact upon fundamental rights. Accordingly, when litigants seek relief directly from the court, they bypass the judicial structure, and open themselves to the risk of presenting incomplete or disputed facts. This consequently hampers the resolution of controversies before the court. Without the necessary facts, the court cannot authoritatively determine the rights and obligations of the parties. The case would then become another addition to the court's already congested dockets. Thus, as we explained in Alonzo, their non-observance of the hierarchy of courts has forthwith enlarged the docket of the court by one more case, which, though it may not seem burdensome to the layman, is one case too much to the court, which has to devote time and effort in poring over the papers submitted herein, only to discover in the end, that a review should have first been made by the CA. The time and effort could have been dedicated to other cases of importance and impact on the lives and rights of others. Second, strict adherence to the doctrine of hierarchy of courts, also proceeds from considerations of due process. While the term due process of law evades exact and concrete definition, this court, in one of its earliest decisions, referred to it as a law which hears before it condemns, which proceeds upon inquiry and renders judgment only after trial. It means that every citizen shall hold his life, liberty, property, and immunities under the protection of the general rules which govern society. Under the present rules of court, which governs our judicial proceedings, warring factual allegations of parties are settled through presentation of evidence. Evidence is the means of ascertaining, in a judicial proceeding, the truth respecting a matter of fact. As earlier demonstrated, the court cannot accept evidence in the first instance. By directly filing a case before the court, litigants necessarily deprive themselves of the opportunity to completely pursue, or defend their causes of actions. Their right to due process is effectively undermined by their own doing. Objective justice also requires the ascertainment of all relevant facts, before the court can rule on the issue brought before it. Our pronouncement in Republic v. Sundagunbayan is enlightening. The resolution of controversies is, as everyone knows, the raison d'etre of courts. This essential function is accomplished by, first, the ascertainment of all the material and relevant facts from the pleadings and from the evidence adduced by the parties, and second, after that determination of the facts has been completed, by the application of the law thereto, to the end that the controversy may be settled authoritatively, definitely and finally. It is for this reason, that a substantial part of the adjective law in this jurisdiction, is occupied with assuring that all the facts are indeed presented to the court. For obviously, to the extent that adjudication is made on the basis of incomplete facts, to that extent there is faultiness in the approximation of objective justice. It is thus the obligation of lawyers, no less than of judges, to see that this objective is attained, that is to say, that there no suppression, obscuration, misrepresentation or distortion of the facts. And that no party be unaware of any fact material and relevant to the action, or surprised by any factual detail suddenly brought to his attention during the trial. I. The doctrine of hierarchy of courts, as a filtering mechanism. The doctrine of hierarchy of courts operates to 1. Prevent inordinate demands upon the court's time and attention, which are better devoted to those matters within its exclusive jurisdiction. 2. Prevent further overcrowding of the court's docket. And 3. Prevent the inevitable and resultant delay, intended or otherwise, in the adjudication of cases which often have to be remanded or referred to the lower court, as the proper form under the rules of procedure, or as the court better equipped to resolve factual questions. Strict adherence to the doctrine of hierarchy of courts, is an effective mechanism to filter the cases, which reach the court. As of December 31, 2016, 6,526 new cases were filed to the court. Together with the reinstated or revived or reopened cases, the court has a total of 14,491 cases in its docket. Of the new cases, 300 are raffled to the court en banc and 6,226 to the three divisions of the court. The court en banc disposed of 105 cases by decision or signed resolution, while the divisions of the court disposed of a total of 923 by decision or signed resolution. These, clearly, are staggering numbers. The Constitution provides that the court has original jurisdiction over 5 extraordinary writs, and by our rulemaking power, we created 4 more writs which can be filed directly before us. There is also the matter of appeals brought to us from the decisions of lower courts. Considering the immense backlog facing the court, this begs the question, what is really the court's work? What sort of cases deserves the court's attention and time? We restate the words of Justice Jose P. Laurel in Ungara, that the Supreme Court is the final arbiter of the Constitution. Hence, direct recourse to us, should be allowed only when the issue involved is one of law. However, and as former Associate Justice Vicente V. Mendoza reminds, the court may still choose to avoid passing upon constitutional questions, which are confessedly within its jurisdiction, if there is some other ground on which its decision may be based. The so-called 7 pillars of limitations of judicial review, or the rules of avoidance, enunciated by U.S. Supreme Court Justice Brandeis in his concurring opinion in Ashwander v. Tennessee Valley Authority, teaches that 1. The court will not pass upon the constitutionality of legislation in a friendly, non-adversary proceeding, declining because to decide such questions, is legitimate only in the last resort, and as a necessity in the determination of real, earnest and vital controversy between individuals. It never was the thought that, by means of a friendly suit, a party beaten in the legislature could transfer to the courts an inquiry as to the constitutionality of the legislative act. 2. The court will not anticipate a question of constitutional law in advance of the necessity of deciding it. It is not the habit of the court, to decide questions of a constitutional nature, unless absolutely necessary to a decision of the case. 3. The court will not formulate a rule of constitutional law, broader than is required by the precise facts to which it is to be applied. 4. The court will not pass upon a constitutional question, although properly presented by the record, if there is also present some other ground upon which the case may be disposed of. This rule has found most varied application. Thus, if a case can be decided on either of 2 grounds, one involving a constitutional question, the other a question of statutory construction or general law, the court will decide only the latter. Appeals from the highest court of a state, challenging its decision of a question under the federal constitution, are frequently dismissed because the judgment can be sustained on an independent state ground. 5. The court will not pass upon the validity of a statute, upon complaint of one, who fails to show that he is injured by its operation. Among the many applications of this rule, none is more striking than the denial of the right of challenge, to one who lacks a personal or property right. Thus, the challenge by a public official, interested only in the performance of his official duty, will not be entertained. In Fairchild v. Hughes, the court affirmed the dismissal of a suit brought by a citizen, who sought to have the 19th Amendment declared unconstitutional. In Massachusetts v. Mellon, the challenge of the Federal Maternity Act was not entertained, although made by the Commonwealth on behalf of all its citizens. 6. The court will not pass upon the constitutionality of a statute, at the instance of one who has availed himself of its benefits. 7. When the validity of an act of the Congress is drawn in question, and even if a serious doubt of constitutionality is raised, it is a cardinal principle, that this court will first ascertain, whether a construction of the statute is fairly possible by which the question may be avoided. Meanwhile, in Francisco Jr. v. Nagmamalasakit ng mga manununggol, the court summarized the foregoing pillars into 6 categories, and adopted parallel guidelines in the exercise of its power of judicial review, to wit. The foregoing pillars of limitation of judicial review, summarized in Ashwander v. Tennessee Valley Authority from different decisions of the United States Supreme Court, can be encapsulated into the following categories. 1. That there be absolute necessity of deciding a case. 2. That rules of constitutional law shall be formulated only as required by the facts of the case. 3. That judgment may not be sustained on some other ground. 4. That there be actual injury sustained by the party, by reason of the operation of the statute. 5. That the parties are not in estoppel. 6. That the court upholds the presumption of constitutionality. As stated previously, parallel guidelines have been adopted by this court in the exercise of judicial review. 1. Actual case or controversy calling for the exercise of judicial power. 2. The person challenging the act must have standing to challenge. He must have a personal and substantial interest in the case, such that he has sustained, or will sustain, direct injury as a result of its enforcement. 3. The question of constitutionality must be raised at the earliest possible opportunity. 4. The issue of constitutionality must be the very least moda of the case. Thus, the exercise of our power of judicial review is subject to these 4 requisites, and the further requirement that we can only resolve pure questions of law. These limitations, when properly and strictly observed, should aid in the decongestion of the court's workload. To end, while reflective deliberation is necessary in the judicial process, there is simply no ample time for it, given this court's massive caseload. In fact, we are not unaware of the proposals to radically reform the judicial structure, in an attempt to relieve the court of its backlog of cases. Such proposals are, perhaps, born out of the public's frustration over the slow pace of decision-making. With respect, however, no overhaul would be necessary, if this court commits to be more judicious with the exercise of its original jurisdiction, by strictly implementing the doctrine of hierarchy of courts. Accordingly, for the guidance of the bench and the bar, we reiterate, that when a question before the court involves determination of a factual issue indispensable to the resolution of the legal issue, the court will refuse to resolve the question, regardless of the allegation or invocation of compelling reasons, such as the transcendental or paramount importance of the case. Such question must first be brought before the proper trial courts, or the CA, both of which are specially equipped to try and resolve factual questions. Wherefore, premises considered, the petition is dismissed.